Is Lisa Yamasaki, and I am the King County Library System Foundation's Executive Director. So wherever in Seattle, King County, or beyond you are joining us from, I hope that you know that Brian and I are very grateful that you are in support of our public libraries.
Yeah, and before this call, Lisa and I were just quickly catching up on both of our systems are having great summer learning programs where kids are out in the branches and learning to embrace reading and preventing the summer slide. So we're super proud of our efforts, and as always, our libraries kind of bounce ideas off each other and often work in collaboration. So a great example of library systems working together and unified around this idea of helping young people through the summer months. These webinars, we love them because it reminds us of the importance of legacy planning. In fact, this week I've been working with a longtime donor of ours who is choosing to leave her legacy through our library as a beneficiary in her estate. And for this donor, it means that her gift will carry on forever. So yay, I won't mention her name, but it's always exciting when somebody chooses to make that commitment. And anyone who participates in these webinars or makes a gift commitment to either the Seattle Public Library Foundation, you'll become a member of our Legacy Society. And I know, Lisa, you have a similar Plan Giving Society. I think it's called your Literary Legends Society. Is that right?
Yes, that's right, Literary Legends.
Great. So Lisa and I are here to always support you. And I know Lisa has Jessica on our team who often works with donors who are working on estate plans. So we are always here to talk to you about including your library, about endowments or other ideas for giving. And our contact information will be at the slide at the end of the presentation.
Great. Thanks, Brian. I have just a few quick things to mention before the presentation begins. First, we are recording this session, and you will receive a link to the recording and the slides after we wrap up today for your reference. Also, our speaker will be answering your questions throughout and at the end of the presentation. If you think you have a question that you'd like to ask, please be sure to use the Q&A box, not the chat, to make sure that we'll be able to see it and respond. And if you see a question that you'd especially like answered or that you've been wondering yourself, please go ahead and use a little thumbs up button next to the question to upvote that. Tiffany will be sorting through the questions by your upvotes so that she knows which ones have the most votes and to be seen first, and she'll get through as many of those as she can. And then finally, when you do sign off today, you'll be prompted to take a very short survey about your experience with this webinar. Please do take a few minutes to complete this. It's really helpful, and your feedback does make a difference in helping us shape future webinars. And to sweeten the deal, everybody who completes the survey today will be entered into a drawing to win raffle prizes, like a bag of books, which I think sounds fantastic. What about you, Brian?
I love it. I think we'll select some of those books off the shelves here.
Great.
All right. And I mentioned earlier that I was working with one donor on an estate right now, and I'm also working with a second. And actually, that's an estate that's closed, and it's a bit more complicated because there are some issues with settling the state, and issues around taxes and whatnot. But I think what that experience is showing me is that it is always so important to really work with a good professional estate planning attorney to complete your affairs and make sure that your legacy is in order and all that. So I am now going to invite our speaker, Tiffany Gordon, to join us on screen. Welcome, Tiffany. How are you today?
Hi, Brian. Thank you so much. I'm doing great. Thank you.
Good. So Tiffany is an attorney at Gordon Pacific, and she is a longtime presenter on our joint webinar series. And Tiffany always sort of volunteers her time and puts great effort into putting these presentations together and taking the time to answer your questions. So Tiffany, both Lisa and I and our library systems are grateful for your commitment to helping educate our donor public about estates and plan giving. So Tiffany, we'll let you take it away.
Thank you so much. Thanks, Lisa. Thanks, Brian. I appreciate it and appreciate the opportunity today. And just in terms of where we're all joining, I saw in the chat folks are kind of saying where they're zooming in from. So I am in North Seattle. I'm right by the Broadview branch, and we utilize both that branch and the Greenwood branch very frequently. My son's favorite day of the week, who is 18 months old, is Wednesdays because that's story time at the Greenwood branch, which he talks about all week long and gets very excited to go to. So just shout out to one of the summer services that we enjoy there. Um, One other thing is Brian and Lisa both mentioned that there is a survey, and it's true. We have been working together for, I think, about 5 years, however long this program has been in existence. And we really do value the feedback. I value that as a presenter. And I'll tell you that we value it so much that one time we did a follow-up session that was just questions that we received and didn't get to in because there are, we have limited time. And so all that to say, please do complete that survey. And the added bonus of being entered to win a bag of books is awesome. So with that, I am going to share my screen and we can talk about foundational estate planning. All right. So I think sometimes when we're thinking about setting up our foundational estate plans, there can be a little bit of this kind of daunting feeling that folks will have of, oh, I have to, suddenly know all the tools that I need and exactly how to implement my personal intentions and my goals. And I like to remind clients, and I want to remind all of you who are tuning in today that that's not the case. I tell clients all the time, talk to me in concepts. Just describe for me how you would envision and how you want things to play out in terms of what happens to your assets after you're deceased. And let me or your attorney worry about kind of the bones of the plan and building the plan. And so I'm going to give you a few things to think about as you are preparing either to meet with your attorney or otherwise, just as you're preparing to kind of think about your own estate planning. And so some of the things to consider here, first, if you're incapacitated, who can you rely on to sort of step in and manage finances, manage healthcare? If you have minor children, make sure that everything is taken care of with them in terms of guardianship sometimes. Um, Similarly, if you have a terminal illness and you're in a permanently unconscious state, do you want life support measures? Do you want those continued or do you want them removed? That is, some of these things are a little scary to think about sometimes, but it's one of the things that is, I think, some of the most important things to consider because you can get some clarity on your own about what is important to you, and then that will allow you as you're working through setting up your plan with your attorney or otherwise, just to kind of have some intention behind that and really think through those things in advance of that conversation. Similarly, following death, do you want to donate your organs, tissue, body, etc.? Any of those things, what makes sense for you. There is, like, for example, there's a willed body program at the University of Washington that I have a lot of clients that participate in that. Some folks, it's really important to them to make sure that they are an organ donor for other individuals who, may need that as a resource. And so thinking about whether those things are important to you and following death, what do you prefer to have happen to your human remains? Particularly here in Washington, we have a lot of options. Of course, buried, cremated, composted, aquamated, which is alkaline hydrolysis. There are a number of things that are available to us. And so thinking about what's important to you is incredibly important. So keep these things in mind as you're thinking through your upcoming conversations with counsel. Similarly, following death, who will be the beneficiaries of your estate? That's something that is probably one of the things that's top of mind whenever you hear the word estate planning is who will who's going to receive my stuff? Do you want your estate to go to charitable organizations? Brian was mentioning a couple of estates that he's working on right now that are the result of estate gifts. And I know, a number of my clients have both Seattle Public Library Foundation or King County Library Systems Foundation included in that regard. It's clearly there's a big group on here today, so it's clearly an organization that is important to, or organizations that are important to a lot of us. And so as you're thinking about your overall plan, think about those charitable organizations that are important to you. Where do you spend your time? Where during life are you spending resources in terms of giving, and what makes sense? What would you like to have happen one day in the future when you're gone? Similarly, are there, your descendants? Do you have kids, grandkids? Are there nieces, nephews, other family members that you want to remember under the terms of your estate plan? So who's going to benefit from your estate one day when you're gone? Um, Importantly, thinking about the specific beneficiaries. When it comes to individual beneficiaries, thinking about, who your people are. Are there people in your life that you want to benefit, but maybe they're minors? And so making sure that you have trust language included under the terms of whatever planning tools you're using. And again, you don't have to come up with the specifics of, I want this type of a trust, but thinking about conceptually, does it make sense to have assets flow into trust for the benefit of some of your beneficiaries, either because they're minors or you simply, they have either, addiction issues or other issues that make them maybe not a great candidate to manage assets all on their own. And so having them put in a trust for them where there's a trustee, a fiduciary in place to assist with making the distributions and the management of those assets to really make sure your beneficiaries are set up for success. Another question that I get very frequently and is something to consider here is if you have a beneficiary who would otherwise qualify for certain government benefits, maybe they're receiving Medicaid or similar, and you want to make sure that one, you remember them under the terms of your estate plan, but that you do it in a thoughtful way so as not to disrupt any benefits that they either qualify for at this point or may qualify for in the future. Okay, importantly, who can you rely on to administer your estate? That's where we start to think about our own fiduciaries of executor, personal representative, administrator. Those are all used somewhat interchangeably. But that is the individual who files your will with the court, creates an inventory of assets, make sure to give proper notice to creditors, ensure that any potential creditors are given notice. If there are valid creditors, valid debts out there, and those are brought according to the procedure under statute, that those creditors are paid, making sure that all of the tax implications are taken care of, meaning final individual income tax return, if that's required to be filed, working with the CPA in order to ensure that that's properly filed, any taxes are paid, whether if the estate is of a level that requires either a Washington and or a federal estate tax return to be filed. We'll talk a little bit more about that in here in just a minute, but as you're thinking about kind of who you might rely on in that regard, who might serve as your executor, really just thinking about what that job is. And these are some of the things to consider of, you want to make sure that the person that you select or the professional that you select is going to do a good job and be able to kind of move through this specific list of tasks, because it's not necessarily intuitive. And a lot of us maybe serve one time, maybe for a parent or a grandparent, or not at all. It's not, that's not uncommon. And so if you haven't done that job, so to speak, there are maybe some things there that you wouldn't otherwise expect, in terms of the tasks at hand. Importantly, where and how will your fiduciary find your asset information, your liability information in the event that you're incapacitated, and they have to step in to assist, managing your finances during your lifetime or managing your health care during lifetime or following your death, making sure that you have, be that a binder or, a list or something in your filing cabinet, just to make sure that folks know, if you can think about it in this way, if you had to sort of drop into somebody else's complete financial life and think about their checking account, their savings account, their investment account, their insurance, their, whether that's health insurance, homeowners insurance, car insurance, all those things, just kind of dropping into someone else's life where you don't know anything about their providers. Think about how you would want to communicate or what you could do to make it easy, in the event that someone does need to do that, either during a season of incapacity or post-death, as to, where are you going to find my accounts, the things that, the third parties that you need to reach out to on my behalf. Okay, I want you to pay your taxes. Not really. I actually want to help you not pay so many taxes. So what about estate taxes? So this is a one-time transfer tax, and it becomes due if decedent's assets reach certain threshold levels. There has been a lot of news this summer, both here in Washington and at the Fed level, related to the estate tax. And so I'm sure that this is something that has come across your radar, whether or not it affects you. But Washington, we have our own estate tax, and our exemption amount is $3 million for folks that beginning July 1st, 2025. So this just changed. And basically that came up from 2,193,000, which applied to decedent's deaths during the period of January 1st, 2014 through June 30th of this year. And this is probably a little bit more background than you might want, but it's interesting. And I think it's worth mentioning because there were a lot of practitioners and a lot of folks that were in leadership within the Bar Association who worked really hard with senators, et cetera, to make sure that this number got, it's increased and adjusted, and it now adjusts for inflation. So historically, it would adjust for inflation annually. So that $2,193,000 number would incrementally increase each year. And then because of the reference in the statute to a specific set of numbers that no longer applied in terms of kind of local inflation adjustments, it stopped adjusting. And so there was some legislation work that had to be done in order to kind of correct the intention that continued to be updated annually for inflation. And so now that has been done. And so that went into effect, like I said, July 1st, 2025. So that number is now $3 million in terms of the Washington estate tax exemption amount. With that, there was also an increase in the potential percentage that's applicable, meaning the tax rate. That's up from, historically it was between 10 and 20%, and now it goes up to 35%. And again, it's on that graduated scale, which I'll show you a couple of charts about that here in just a minute. And I'm mentioning, I could talk all day long about taxes and I won't bore you with that, but wanted to just sort of flag these numbers for you, because as you're considering and thinking about some of the things that you might want to talk about with your own estate planner, or thinking about things that are just, you want to have on top of mind as you are thinking about your own estate plan, estate taxes could be one of them. And so just having kind of some of these numbers flagged for you, so that way you know to, oh, I do need to ask a question about this, or I need to have a conversation about this. In terms of the Fed, for folks who are dying in 2025, the exemption amount is $13 million. $990,000 for an individual. We effectively double that for a married couple to $27,980,000. Now, I joke that I hope to have a federal estate tax problem someday, but I don't currently. So those numbers are significantly higher than the Washington amount, but as you are probably not surprised, just based on even housing prices and what we've seen with that in King County, that $3 million, well, is a large number. It does affect a significant number of people. And so that's some planning that we as Washingtonians often face that we need to do. And so here's just a chart of the rates that were in effect prior to July 1st, 2025, and then the change in rate going from 10 to 35%. Beginning with July 1st, 2025. And these are on the Department of Revenue's website if you have an interest in looking at some more detail on the Washington estate tax. And then the Fed ranges, it's largely 40%, but it ranges from 18 to 40%. And one of the questions that I know I've been getting a lot, and I know just talking with other practitioners that clients are asking, this is sort of a buzz question right now, is, well, as part of my tax planning, should I become a resident of another state? Should I leave Washington from a domicile perspective? And that's something that historically I would have, a couple questions about that, maybe a year. I did not have anyone who has done that. But I did get the question. And now it sounds like people are really considering that more in light of the fact that the applicable percentages have increased in terms of potential exposure. So my point is here, what other estates have an estate tax? So consider this if you are thinking about relocating to avoid the Washington estate tax. Don't go to one of these states because you might end up in a worse situation. And then so we have the estate tax, and then the gift tax is kind of the sort of a counterpart of that. Washington does not have a gift tax, and we'll talk about kind of one of the interesting and helpful planning, not necessarily a planning tool, but sort of a planning idea or kind of a planning scheme that goes along with the federal gift tax and the fact that Washington does not have a gift tax. So at the federal level, we have a lifetime exemption amount, and that's that $13,990,000 figure that I mentioned. Because why would it just be 14 million? So it's easy to say. But that number is each of us as an individual has that as our lifetime gift tax exemption. If we make gifts to any individual over the annual exclusion amount, which is that $19,000 number, and there's a box about that right here on this slide. Oftentimes folks will hear about, oh yeah, well, my neighbor or my uncle or whoever, gifts each of his children $19,000 a year, and the reason behind that often is, and the significance rather, is that is the annual exclusion amount for the federal gift tax. And so what that looks like is basically you can gift up to $19,000 per person per year without tripping any reporting requirements, and also without chipping away at that bigger number, that 13.99 million, which is the lifetime exemption amount. So say, for example, I had 3 children and I gave them each $19,000 in the year 2025 as part of my gifting strategy. There would be no reporting there. And again, this is only federal. This is not a Washington tax. Washington doesn't have one. However, say that I gave them $20,000 each. Well, then I have $1,000 for each of those gifts that is going to chip away at my overall big lifetime exclusion amount, which is that 13.99 million. And the way that is connected to the federal estate tax is it's your gift tax exemption amount during life, and then at death, whatever remains intact in that $13.99 million exemption amount is effectively your remainder, your estate tax exclusion amount. So what does that mean? So say during my lifetime, I gave away $4 million. And then what would happen, and it was above the $19,000 annual exclusion amount. So I would file my gift tax return, I would report that. I wouldn't have to pay any tax at that time. But what it would do is it would take from my $13.99 million exemption amount, it would reduce that by the $4 million in gifts that I made. And so that would effectively leave just under 10 million as my remaining estate tax exclusion amount at death. So that's how they're connected. So it's one number, that 13.99 million, but it is effective for gift tax purposes during life, and then at death it's effective as your estate tax exclusion at the Fed level. And so what is a gift tax? I've talked a little bit about it. What is it really? And it is a tax on that the donor pays, the person making the gift, not the recipient, but the person making the gift, if they make gifts in excess of that overall exclusion amount, which is almost 14 million, then they're required, they may be exposed to some gift tax. And so the donor is the person who pays it. It's not something where, like in my example, I gave $20,000 to each of my 3 imaginary children. They're not going to be paying tax on the receipt of that gift. It's something that I as the donor pays. I would file my gift tax return, report the gift, and then if I were above the 14 million for my or the 13.99 million for my lifetime gift tax exemption amount, then there would be some tax due. So that's how it functions. Again, there's no gift no gift tax in Washington. And a couple of other things to consider in terms of gifting strategy. A lot of times folks will say, all right, well, I want to pay for education expenses for my kids, my grandkids, etc. And so that's, the question of what about medical and educational expenses? What makes sense there? And are those subject to potentially subject to the gift tax? And there's a very specific way to go about paying the medical or educational expenses of other individuals that avoids both. It can be more than that $19,000 annual exclusion amount, and it won't chip away at your lifetime exemption amount if the payments are made directly to the healthcare or educational facility directly. So for example, say that your kids go to ABC school and you write your check directly to ABC school on their behalf. That's a gift for them. It's a benefit to them, but it doesn't count from a gift tax perspective. It's not going to be count toward your $19,000 annual exclusion amount with regard to them, and it's not going to chip away at your lifetime exemption amount because you made it directly to the educational institution. Rewind the tape. I write a check to my child for the tuition for ABC school, and then my child takes it from their account and pays ABC school. That does not qualify. It needs to be directly to the institution. So that's something that's important as if you're thinking about gifting strategies. There's a question regarding are all gifts of all assets created equal? And I've included that here because the answer is no. And this becomes really important when you're thinking about your charitable giving. So for example, if you're going to give to the Seattle Public Library Foundation or the King County Library Systems Foundation, not all gifts are created equal. And what I mean by that is, in terms of looking at your overall assets, one thing that is really handy and can really get the most bang for your buck is being able to, during your lifetime, if you're of an age of taking required minimum distributions from your retirement accounts, for example. And maybe you don't necessarily need, all of those funds for your, annual living expenses, and you're also charitably inclined. You can direct that the required minimum distribution or a portion thereof go directly to the charitable institution or the charitable organization. And then the charity is not going to have to pay income tax on the income that's baked into that distribution in the way that an individual would. So for example, say that I'm of age to take required minimum distributions, and I have $50,000 that is going to come to me in that form, and $10,000 of that 50 is income that has to be taxed. I take the distribution, I report the income on my income tax return, and I, as an individual, have to pay income tax on that $10,000 of income that's baked in. But if I instead directed that required minimum distribution go to King County Library System Foundation or Seattle Public Library Foundation or any other charity, qualified charity, then they're not going to have to pay income tax on the 10 grand in the way that an individual would. Similarly, when you're thinking about overall assets and gifts post death, so when you're thinking about your overall estate planning and what might make sense for any given, distribution or gifting inheritance scheme of, I have some charities I want to benefit, but also some individuals. Think about including the charities as beneficiaries with regard to those retirement accounts, because that same thing remains true. They are going to be able to get dollar for dollar from that gift, whereas if you had children or other, human beneficiaries are going to be subject to the income tax when they take the distributions out from those accounts post death. So that's something just to keep in mind in terms of overall asset makeup is handy. And unless you say, I love, I love to pay income tax and I want everyone I know to pay, that can be a really good tool or really good asset for remembering your charitable beneficiaries. The other question that is on here that I want to touch on is, what is a deathbed gift? So as I mentioned, Washington doesn't have a gift tax. We just have to think about the federal gift tax. And so as a result of that, Washingtonians are, oftentimes part of their overall estate and tax planning strategy involves making larger lifetime gifts to their loved ones, to charity. But when we think about the gifts to individuals, this can become important because, say, for example, I have $10 million in my estate. And then, as we know, my exemption amount is $3 million. And so that leaves 7 million, the difference between 10 and 3, as potentially, potentially could be exposed to the state tax when I die. Whereas if I make lifetime gifts of that amount, say I gift 7 million, just for ease of math, there is not going to be any gift tax because there is not one in Washington. I'm not rising to the level of 13.99 million federal exclusion amount. So I've got that exemption amount to give before any tax would be due at the federal level. And the result is I only have 3 million left in my estate for potentially, from an estate tax perspective. So that is sort of a kind of a quick math problem in terms of lifetime gifting. But the deathbed gift in specifically is if folks, are getting older or they're terminally ill or they know that they're going to be, facing end of life, in short order. They can make large gifts because they know that they're not going to need those assets, and they can make large lifetime gifts to individuals, to their loved ones, to reduce their estates for estate tax purposes, and also not be subject to gift tax because Washington doesn't have one. So that's those are some important things to consider when you're thinking about the tax perspective of your overall planning. So before we get into the tools, I wanted to look really quick at some of the Q&A so that we can chat about those. Here we go. Okay. Should the executor be a family friend, a family or friend, or a professional or legal organization? That's a great question. And we'll talk a little bit more about the fiduciary rules when we talk about the tools that are coming up next. But it really depends. From an executor perspective, that can be any of those individuals that you suggested in your question. It could be a family member. It could be my brother, my sister, my adult child, my niece, my nephew, my parents. It could be any family member, or it could be a family friend, or that we have a lot of really good resources, particularly in our geographic area, of professional fiduciaries, meaning there are certainly big banks. So there's could be like a large trust department that qualifies in that regard, but there are really different shapes and sizes of professional fiduciaries out there that can make sense for any given set of circumstances. More and more I'm seeing folks say, I don't want to burden my children, or my kids don't live here, or I don't have kids. So a lot of times if you don't have a kind of an obvious person in your life, or you say, you know what, everybody in my family is, busy with their own lives, I don't want to burden them with this, then a professional fiduciary can certainly make sense in many, many circumstances. And we have a lot of, we had a lot of different types of fiduciaries in that regard. So it can make sense for small estates, it can make sense for large estates, and everything in between. So it really just depends on your particular circumstances of who might fit well in that role as executor. Similarly, we'll talk more about the other fiduciary roles of trustee and agent for finances and agent for healthcare. Okay, just to clarify, the numbers mean that any estate amount under 3 million is non-taxable. That's correct. From a Washington state estate tax perspective, if you have assets under 3 million, then you're not required to report or pay, or there won't be any exposure to estate tax in Washington. Okay. Question about taxes. Does this mean total assets, including real estate, securities, cash, vehicles, household, jewelry, etc., or is it divided in some way? That's a fantastic question. So when I talk about the estate tax in your estate, you really are looking at everything. And that's real estate. That is, any investment accounts you have, cash, gold bricks, household items, vehicles, all of those things. And importantly, it also includes life insurance proceeds. So if I have $1 million life insurance policy on my life, for example, even though I'm really not going to use that as an asset because it's the death benefit doesn't pay out until I'm gone, so it doesn't feel like it's an asset, it's countable for estate tax purposes. And so it's really everything, all of your retirement accounts, every asset that you may have that's titled in your name. If you received a trust from your parents or some other family member, and so there are assets that are being held for your benefit, but you don't actually own them, that's something that could be, that is typically not something that would be included. Now, you of course want to look at the specific terms of the trust because this is very different than setting up a revocable living trust for myself. Those assets would indeed be included in the estate, in the gross estate, but you want to excuse me, so you want to check the terms there, but yes, by and large, it's really everything. It's all those things in your question. Okay, if I die or reside in a non-estate tax state, say for example, Nevada in this example, but my kids live in an estate tax state, do my kids pay estate tax? No. So if you are a resident of a state that does not have an estate tax and you die there, then, and that's, where your assets are, you're not going to be subject to state estate tax because there's not a state estate tax in the state that you live in. However, where this can be, where there's some room for generational planning, and I often tell clients to consider this, even in circumstances where, they have adult children and they're financially responsible, et cetera, is, for example, say you live in California and there's no estate tax, but your kids live in Washington. And so if they inherit from you directly and suddenly each of them gets $3 million, just because that's the example, that goes into their own bank account, well, then suddenly their own estates they're going to need to talk to their nice estate planning attorney about how to deal with the fact that through their parents' generosity, they could potentially be subject to the estate tax one day in the future when they die, just because they've got this extra 3 million as a result. And so one thing to consider there is, although simply the triggering event, which is your death, if you are in a non-estate tax state, you're not going to owe estate tax at that point, but your generosity could result in an increase in asset value for your children or otherwise. And if they are in states that have an estate tax, when they die, there could be estate tax exposure. So one thing to consider there, this is a long-winded answer, but one thing to consider there is if your children do live in a state like that, having assets flow into trust for their benefit rather than to them outright to keep it out of their estate for estate tax purposes. And there are certainly other reasons to do that, but there are tools available to kind of circumvent having the future generation have to pay estate tax by the generosity of the parents. I'm interested in hiring a company or other professional to be my executor. What are my options? In James Wiley's question about abuse and extra charges, how can that be avoided or safeguarded? I didn't get to James Wiley's question yet, but I'll look at that. And just kind of generally be able to talk about how to avoid abuse or other charges. So in terms of being interested in hiring a professional to serve as executor, I'm happy to provide. There are a ton of them. Even a Google search of Seattle professional fiduciaries will get you probably 10 hits that just come right up. But there are a number of them that I work with regularly. And like I say, there are bank trust companies, there are, local trust companies, there are just local fiduciary services, et cetera. And they have different fee structures, and you can reach out and say, talk to a human, see if it's somebody who you might have rapport with and might be a good fit for your particular situation. And you can get a feel for their fee structure. In terms of avoiding abuse and extra charges, how can that be avoided or safeguarded? From a professional standpoint, anyone that you would likely hire, I mean, in this scenario, they're professionals. And so they do this all the time. So it's really unlikely that there's going to be a fraud or abuse. That doesn't mean it doesn't happen. But you could include language. One, the beneficiaries are going to have there's going to be transparency with the beneficiaries there. And so if there's something unusual in terms of fees, et cetera, then the beneficiaries are going to see that and have the ability to complain about it. Or to, bring it to light. If it's a problem, they can certainly petition the court over it. But you could also include language of, having a co-fiduciary, or having, another individual appointed under the terms of either your will or trust document, that has kind of a notice party and has the ability to review the detail from the fiduciary. Because having that knowledge shared is really where the power comes from. Okay. I understand that different states have different tax rules, but I establish a will or a plan in Washington. Is there reciprocity between states? If I move to Oregon, does my will remain legally valid, or does it need to be rewritten and registered in Oregon? That's a great question, because we really are a nation. I keep saying that's a great question. These are all great questions. Let me just say that. We have we're global people and we do move around. And so you want to make sure that your plan is one, comports with local law wherever you are domiciled at the time, and that it represents your current intentions. So the answer is, in short, your will would still be valid. I have probates that I'm working on right now where the decedent moved here from another state and never updated their plan. And so we're probating a will from Louisiana or, wherever the person lived previously. And those documents are indeed valid. So it's not that your will would be invalid if you move to Oregon, but they have different statutes and different rules. And I know just from an estate tax perspective, they have a different exemption amount than Washington. Theirs is 1 million, so it's even lower than here. But that being said, what I recommend that clients do always is at least have local counsel review your documents. Sometimes that can be less cost effective and less efficient than just having them draft a new will in the new state, just to make sure that everything is updated. It's with, that attorney's forms that they've worked on for hours and hours over the course of the years, and they're very familiar with kind of local nuances. So it doesn't become invalid. But it is, from my perspective, a best practice to at least have local counsel review it, and likely they'll want to update it for the new state. If I move to Canada, would the will be valid? That's a great question. I don't believe that it would be invalid. I think it would be similar to moving state to state, but I do not practice there. And so I would say definitely have local counsel review it, because there are some places that don't have, like, for example, if they're trust language under the terms of the will, some places don't really recognize that in terms of that trust structure. So there are big differences in some places like that. So I would say definitely have local counsel look at it. Okay, I'm going to do 2 more and then I'm going to move on to the documents. So for a married couple, will any assets of the first dying spouse simply transfer to the surviving spouse without any Washington or federal tax implications? Great question. Yes. So we have the deductions to think about with regard to estate tax. And I think that this is on one of my slides, but I should have called this out specifically, is that we have the unlimited marital deduction. So there's not something where if I die and I've got $10 million in assets and everything flows to my surviving spouse is not going to have to write a check to the Department of Revenue. There's an unlimited marital deduction that qualifies. And so this is not something that would typically affect one or both spouses. This is going to be a tax that the estate is going to pay at the death of the second spouse in those circumstances. Now, that could be different if a significant portion of assets went to parties other than the surviving spouse when the first spouse dies, but by and large, no, there's gonna be a significant qualification for unlimited marital deduction in most circumstances. And so again, assets that are going to flow to the surviving spouse are exempt. And there was another part of that question. And now I can't see it. Okay, I'm going to move on. When a spouse dies, there's an unlimited passing of wealth to the surviving spouse without federal estate tax. What happens in this case for Washington state? That's absolutely correct. So it's the same. There's an unlimited marital deduction, both from an estate tax, from a Washington estate tax perspective, and also from the Fed. Okay. Okay. So now getting into kind of some of the tools. So the first one that I want to talk about, and I've sort of alluded to some of these throughout the conversation, is the durable power of attorney. And I tell folks all the time, I think that this is really the cornerstone of a good estate plan. And frankly, maybe the most important piece, because it takes effect during your lifetime. So this is something where I am appointing an agent under my power of attorney for healthcare, for finances. Does not have to be the same person. It can be, but it doesn't have to be. It could be a professional, it could be an individual. But I say that it's the most important because it comes into play during life. And it's important what happens to your assets one day when you're gone, but it's more important what happens to you and your assets during a period of incapacity. So in the event that you're incapacitated either for a season or you have a long-term illness, for example, most of our families, are affected in one way or another by Alzheimer's or dementia. And so circumstances like that come to mind very quickly in having this conversation. And so we want to make sure under the power of attorney, we're able to have somebody on deck, so to speak, that can step in, assist with finances, assist with healthcare, in the event that they need to. And sometimes that can be for a season, sometimes that can be longer term. I think a lot of times folks will think about this as end of life decisions, which is true. Do I want life support? Do I want artificial food and hydration? And that can be very true. That is part of the job from a perspective of agent or attorney in fact for healthcare under power of attorney. But it's not the only job. This can be a longer term commitment, can be a longer term job, meaning for example, even in my own life, my mom was ill for a number of years prior to her death, and I was, serving in that capacity for her, both from a healthcare perspective and a financial perspective. You're making sure that that individual has their dental appointments. They're getting their 6-month cleaning, they're getting their checkups. They're, if they're managing an existing condition, or if something pops up, that they're, seeing the specialist that they're required to see for um, best provider for whatever circumstances they find themselves in from a healthcare perspective, making sure that in the event that that person needs more care in home or assisted living, things like that, that is can be part of that job. And so that's why I say it's important to think about it from an end of life perspective, but it can also be an aging in place perspective, or just general aging perspective, both from a financial perspective and a healthcare perspective. And what happens there is basically, in the event that a person needs more assistance to pay the mortgage, make sure all the things that we do in our own lives with regard to finances are taken care of in the event that we couldn't do them. So somebody has to come in and make sure that, like I say, my mortgage is paid, my income taxes are filed. They're working with my CPA to make sure that that happens. If I'm making quarterly tax payments, that I'm making those payments. Some folks will think about if you're, if you're a little older and you're of required minimum distribution age from a retirement account, making sure that those RMDs come out. So really it is managing kind of all the financial piece, all the healthcare piece for another individual in the event they need it. And so as you're thinking about this, think about, would this be a professional? Would this be, a family member? Would this be a friend? What's going on in that person's life? Do they have really busy business owner, a lot of, multiple children, 3 pets, and, what does their life look like? Because you want to make sure that you have selected the right person for the job. And when it's possible, to ensure that to be certain that you include a backup for that person as well. So that way, in the event your, first person can't do it, that you have somebody in place as a secondary person. And so for a durable power of attorney, in order to be validly executed, it needs to be signed, dated, and acknowledged before a notary or attested to by 2 competent witnesses in the presence of the principal. So you're the principal if you're making the document, and then the agent is the person you're appointing, and you need to sign, date, and either acknowledge it before a notary or have 2 witnesses sign with you. Okay, so that's the one that comes into play during lifetime. Now we're going to talk about wills and revocable living trusts. Those are the 2 primary kind of foundational planning tools from a perspective of what happens to my stuff. But you're appointing a fiduciary there to manage assets and make sure that creditors are the creditors are notified, that they kind of work to wrap up the business of life, and they're really a roadmap for doing that. So the first is the will, and I tell folks that probably 9 times out of 10, a will works for most Washingtonians, meaning that they, regardless of shape or size, you can incorporate estate tax planning. You can incorporate, various trusts for either surviving spouses, for children, for beneficiaries who might have certain special needs, etc. You can do all those things under the terms of a will. The difference really between the will and the revocable trust, which we're going to talk about in a minute, is under the terms of a will, it's a roadmap that you execute during your life, and then it doesn't really become effective or like a living document until you're deceased. And then what happens is it appoints your executor. It says, I appoint Mr. Smith, or I appoint ABC Fiduciary Company as my executor. And that person gathers all of your assets. They figure out, where all your assets are, your real estate, insurance policies, accounts, etc. And for those that are, come under the terms of the will, make sure that everything is distributed accordingly under the terms of, what you've laid out in your will. So if you've remembered charitable beneficiaries for some assets, or some percentage or dollar figure for assets, or some individuals, etc., then what happens is the executor steps in, they file the will with the court. They get what's called letters testamentary, which is a 1-page document that essentially gives them the power to step into the shoes of the deceased person. They can sell their house. They can, they file their final income tax return, can file an estate tax return if they're above that 3 million exemption amount for Washington and the 13.99 for the Fed. And then they really go out about the kind of the wrapping up the business of life. It really is similar to if you were to shut down your business, or if someone were to come in and shut down your business. There's some financial administration that occurs there. And so that all occurs under the terms of the roadmap of your will. And the requirements here, we've got it's written, signed by the testator, the person making the will, and then it's signed by, 2 or more witnesses in the presence of the testator. Now, what about the revocable living trust? Now, this is, it can provide a roadmap in the same way that a will can, but it really is active during your lifetime, and it governs distribution of assets at death. So it's completely changeable, just like a will. You can change them at any time during your lifetime as long as you have capacity. But what happens with a revocable trust that's different than with a will is it really is kind of a bucket that holds title to your assets while you're living. So for example, if I chose to use a revocable trust as my primary tool instead of a will, I would change title to my house. Instead of having it be in my name, Tiffany Gorton, as an individual, it'd be in my name, Tiffany Gorton, trustee of the Tiffany Gorton Trust. And so there's some title changes that occur when you are executing this type of a document. And if it's properly funded, meaning you've transferred title, you've changed title to the trust during life, then probate proceedings might not be necessary. But I tell people in Washington, because our probate process is relatively streamlined and really is just what is probate is a court supervised process of gathering and distributing assets, paying creditors, and ultimately distributing assets for beneficiaries. It's sort of it's a forum for doing that. Whether you die with a will or you die with a revocable trust, there's going to be some administrative activity. So for example, I own a house. If I die with a will, my house is going to be sold by my executor and the proceeds are going to be distributed according to the terms of my will. If I have a revocable trust and my house is titled in the name of the trust and I die, my successor trustee is going to step in. They're going to sell the house and they're going to distribute the proceeds according to the terms of the trust. So you're really doing either a probate estate administration or a trust administration, and they look very similar. So this is in Washington. Now you may have either had some experience in a state like California, for example. There, everyone uses a revocable trust because their probate process is clunky. It's expensive and it's not streamlined in the way that it is here in Washington. Here, we file a will with the court, we pay a $240 filing fee, and then we're off to the races, so to speak. It's not that way in every state, but in Washington, we're really fortunate because it is. So it's not the onerous process that it can be in some other places. And that's why I say that very frequently folks will utilize a will as their primary tool. And now, due to, lifetime gifting or many other reasons that folks might have other types of trusts that they incorporate into their plan, we're just talking about foundationally setting up a will or setting up a revocable trust as sort of a first step. Now there are other pieces that can come into play that do specific things, but this is for kind of primary planning, so to speak. So again, what is probate? It's a court supervised process of settling a deceased person's estate, basically settling their debts and transferring their assets. Again, the personal representative gathers all the probate assets, notifies creditors, files any tax returns, distributes assets according to the terms of the will. And that's very much what happens under a trust administration. It's just the trustee that's making sure that this occurs. What are non-probate assets? So assets that are titled with joint tenancy with right of survivorship. So think about bank accounts, investment accounts, anything that has that type of JTWROS language. And those assets, along with something subject to community property agreement, assets that are held in other trusts, life insurance policies, or TOD or POD accounts, transfer on death or pay on death accounts. All of these assets are designated or kind of characterized as non-probate assets because they don't require the probate process in order to transfer. So for example, if you have an account with Charles Schwab and you have your spouse or any other individual listed as a joint tenant with rights of survivorship, what happens at death is they'll want a death certificate, and then the balance of that account is going to be owned by the surviving joint tenant that's on that actual account. And so this is important to think about because for tax planning purposes, or for just general planning, you want to make sure that any assets that have that titling, that you really intend for that asset to pass via contract right away at death, rather than being available to fund certain trusts or otherwise pass under the terms of your will. Because non-probate assets, when they have this associated contract, either it's pay on death, or any beneficiary is designated, or there's a joint owner, it is in those circumstances, it's not going to pass via the will. It's going to pass under the terms of the contract. Similarly, property that's held in trust, and that's kind of the function of a revocable trust, is assets are titled in the name of that trust, and what happens there is those assets are going to pass under the terms of that trust. They're not going to be subject to the terms of the will. Similarly, life insurance policies, those oftentimes will have a beneficiary designated on them. And so likewise, if you have an insurance policy and it has one of your children as beneficiary, that's the person who's going to receive that policy at death. It's not going to pass under the terms of the will if you have an associated beneficiary designation there. And property subject to a community property agreement. So some spouses, some married couples will have an agreement that characterizes assets as community property, and then also provides that the surviving spouse receives all of those assets at the death of the first spouse. And so that is exactly what happens. The property title will pass to the surviving spouse. That's considered a non-probate asset. The issue there is that's as far as it goes. It just is between spouses. So in order to direct where assets go at the death of the second spouse, you would need to set up a will, revocable trust, or make sure that you have an additional beneficiary designations on certain accounts. Okay. When to consider updating your plan: weddings, babies, funerals, liquidity events. I tell folks that when they have big life events, that's really the time to actually just think about, it might not mean that they have to make an update, but just to consider, hey, does the fact that I have a grandchild, or that, a family member has died, or I've gotten married, or I've gotten divorced, I sold my business, in any of those circumstances, so big life events, like I say, you want to at least consider whether or not it makes sense to make an update to your plan. And so with that, I am going to switch back to answer some more questions. A few years ago, I heard it is better to leave a specific amount rather than a percentage, because charity may hold things up trying to prove total value of the estate is accurate. Will leaving a percentage of one specific banking financial account in a will avoid this delay or complicating probate? I don't know if it's necessarily better to leave a specific amount or a percentage. A couple things. You want to think about this from a global perspective of what are your assets? What do you intend to happen? And you don't have to necessarily think in dollar figures or in percentages, but just as a general thought of, what do I want the charity to get? And you can even use a ballpark figure. And from there, I think working backwards to say, yeah, it makes sense to have a percentage of my overall assets, or to your point, if you do have a specific account that you would like them to receive, then you can certainly put them as a designated beneficiary on that account, or for a portion of that account. And that is very clear in terms of a gift being made. But I don't think that charities have a reputation for holding things up to try and prove accurate values of an estate. So I wouldn't say that's the only way to do it. I would say think about, one, your charities, and two, your own assets, and really what in a perfect world would you would want to have happen with kind of your overall asset makeup, and then think about it from there. But you can certainly do it as you asked there, if you can include a charity as a beneficiary of a portion or a specific account. My brother asked me to be the executor for his estate. I'm fine with that, but I've seen conflicts within friends, families, and estates about trusts, and even financial abuse and fraud. $3,000 a month for lawn service from the trust organization. Recommendations on how to manage possible family conflict and avoid skimming by the finance professionals. So from a managing family conflict perspective, I think that having really clear documents is the name of the game there. That being said, I spent several years during my practice, with about half of my practice being litigation, in trust and estate litigation, and the other part being planning. And I think that litigation experience certainly informs my planning. But I think really making it very clear what you want for each individual and each organization, and how you want, having clear documents is step number one. But in terms of you serving as the executor, I would say, just make sure you're dotting your I's and crossing your T's. You have recommendations of either professionals such as a CPA or, other professionals that you might work with in as part of that administration. I would say use those reputable services. Um, and really, spend the time to review the work of the other third parties that are helping with the estate to ensure that your duties are being met, and that, all of the associated expenses are real expenses. Um, from with the perspective of the trust organization, that's unfortunate and also troubling because, like I said earlier, I don't see that a lot with professional fiduciaries, that there's, a malicious, a fraudulent intent in that way. And so I would say, if you're thinking about utilizing a professional fiduciary, just make sure that you're getting, somebody that comes to you recommended, I would say, somebody who, has had experience with other individuals. You've been able to talk to someone about exactly what their experience was, because that's really the best you can do in terms of selecting somebody. And then, of course, making sure that there's transparency with beneficiaries, which is appropriate and required, and the possibility of including another individual under the terms of the plan, that would be kind of a notice party and have access to the financials and reporting from the fiduciaries. For education expenses, does that include student loan payments as an exemption? No, that is something different. This is specifically when I was talking about the gift taxes, it specifically goes to the financial, or excuse me, to the educational facility, not to like Sallie Mae or someone. Durable power of attorney. I'd insist on paying a friend to do this. Can you suggest a scale? Percentage of assets under management, et cetera. That's a great point. And yes, you should insist on a friend or family member who serves as a fiduciary that they be paid. There's no involuntary servitude. So under Washington law, they're entitled to a quote unquote reasonable fee. And what I find to be reasonable and what would be considered probably reasonable by getting court approval are two different things. I think that you can probably see like 50 plus bucks an hour, maybe, for more technical tasks. So if they're meeting with a CPA, if they're, going through, preparing their documentation for an accountant, things like that, versus somebody who's cleaning out the shed, so to speak, that's more of a, closer to probably minimum wage, 20-25 bucks an hour, in terms of the task. Nobody's really getting rich in serving as an agent, or an executor for friends or family. That being said, because a lot of times folks will have somebody with a professional background, not necessarily a financial background, but somebody whose time has a price tag, and it's clear in spite of the fact that they're not a professional fiduciary. One thing that I do see clients do a lot is leave an additional gift to that friend, and say, I want you to charge your time, but I'm also leaving you, X number of dollars as a thank you for either being willing to serve in this role, or if you are actually required to serve. Suggested way to find fiduciary executor that fees are hourly rather than just a percentage of the estate, mostly doing tax return and deducting taxes due before distributing financial accounts to beneficiaries. So when you're thinking about using a professional fiduciary, I would say reach out to the one that you might, or a couple of them, because many of them are indeed hourly. The ones that charge a percentage is usually if they're having assets under management, they will, like if they are in a large bank or trust company, that's a more typical fee structure there. But I would say, talk with the individual outfits that you're considering, and you'll be able to get very specific detail as to whether they charge hourly, what their hourly rates are. they'll have usually a team of folks that do somewhat different things inside of the administration, and they have varying rates.
Okay, I think we are just at about time. We're right at 1:10, so I think we are going to wrap up our Q&A for now. And Tiffany, I just want to give you, on behalf of all of us, our sincere thanks for taking time to share this information today and all of the ideas with us. I hope that everyone online has also found it to be very valuable. I know I have as well. We will be sending a follow-up email with a recording and slides in the next couple of days. So please be on the lookout for that soon. And as a reminder, when you exit the seminar, the webinar today, please do take the quick survey that you'll be prompted to do. And everyone who completes that survey will be entered to win a prize, which could be a grab bag of books, which would be a great thing. Thank you, Tiffany, so much.
And finally, as all of you think about your own legacy planning, please remember that a charitable bequest is one of the most meaningful ways you can support a nonprofit. And, you know, you can include your library. And as Tiffany pointed out today, it's not always about just including your favorite charities in your will or your trust, but also, you know, as a beneficiary of your life insurance or your IRA policy. Those are really great ways to help the charities that you love and continue your legacy. So, and as always, please let us know when you're including us, either the King County Library System or the Seattle Public Library System in your estate plans. That way we can always make sure that we honor your wishes and have that properly documented. And you can join those great giving societies that we're part of, that we each have to be invited to special events, etc. So reach out to us if you have additional questions about anything. We're here to serve you. And as always, we thank you for supporting your public libraries. Have a great day. Bye, everyone.
Thank you.